The Committee on Criminal Jurisprudence will come to order. Clerk, call the roll.
Chair Smithy,
Here.
Vice Chair Wu, Representative Bowers, Representative Cook,
Present.
Representative Jones, Representative Little, Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Riddell. We've got a quorum.
A quorum is present. Members, thank you all for being here. You're real troopers to be here after the late night we had last night. So we welcome all of our witnesses and our bill sponsors. We would just a couple of announcements. We're going to try to get through this real quick so we can get to the floor by 10 o'clock. We're going to hope to sandwich enough time in there for a committee photo if we have everyone here by then. Okay. Never mind on the committee photo. Well, you look nice every day. And so, but for the witnesses, we impose a 2-minute time limit on witnesses. And we certainly welcome you to testify. If you'd rather register and not testify, you're welcome to do that. But either way, you need to sign or fill out a witness affirmation form on the kiosk out in the front lobby. And so, where's my list? I think we voted on pretty much everything we had last night to vote on. So at this time, the chair would lay out Senate Bill 2595 by Senator Middleton and recognize Representative Alverson.
Thank you, Mr. Chairman, members. Senate Bill 2595 is revisiting the idea of criminal activity while harming others while wearing a mask and attempting to conceal your identity. It is a little bit different than the bill that we heard before. So this bill doesn't enhance a criminal penalty for an existing crime. This bill creates a narrowly tailored Class B misdemeanor for specific behavior, which is to harass, threaten, or intimidate someone while intentionally attempting to conceal your identity. It provides broad affirmative defenses for prosecution for folks that could show they were wearing a mask for holidays, health protection, religious expression, artistic performances, job-related safety, etc. So that is what it does. It's pretty straightforward. I think it's actually a one-page bill, and I'm happy to take any questions. I'd like to reserve my right to close.
Okay. Our record needs to show that Speaker Moody is present and also Mr. Riddell is present. And members, any questions for Dr. Alverson? Okay. Hang loose because I don't show any witnesses. Let me ask, is there anyone here to testify for, against, or on Senate Bill 2595? Seeing no one, Chair recognizes Representative Alverson to close.
Thank you, members. I appreciate your attention, and I close.
Okay. And so we'll leave 2595 pending for now because until we get some more members here. And thank you, Dr. Alverson, for laying that out. Next, the chair lays out Senate Bill 1980 by Senator Hall, and recognize Representative Harris to explain the bill.
Thank you, Mr. Chairman and members. I appreciate the opportunity to lay this bill out this morning. This bill is crafted with the intent to increase protections for peace officers, parole officers, community supervision officers, and emergency services personnel, individuals who risk their safety every day to uphold our laws and serve the people of Texas. Under current law, individuals who assault certain public servants may only face relatively minor consequences. This bill increases the penalty for such assaults. Specifically, it amends sections 22.01C and D of the Penal Code to raise the classification of assault from a Class C misdemeanor to a Class B misdemeanor when committed against a parole officer, community supervision officer, or peace officer carrying out their lawful duties. In addition, the bill includes a presumption clause to aid prosecutors. It presumes that an offender knew the victim was a public servant if the individual was wearing a badge or uniform clearly identifying their role. This provision is designed to close the loophole where an offender might claim ignorance of the victim's official capacity despite visible indicators. This bill also expands Section 38.15 of the Penal Code, which pertains to interference with public duties. It adds parole officers and community supervision officers to the list of protected roles under this statute. By including these officers, who often work in high-risk environments and deal directly with individuals under state supervision, the bill ensures that they receive the same legal protections as other public safety officials. Finally, the bill introduces a rebuttal presumption regarding the publication of personal information. If someone intentionally publishes the address or other personal details of an officer or their family members, the bill presumes that the act was done to obstruct or interfere with the officer's duties. This addresses a concerning trend where doxing has been used to threaten or intimidate law enforcement personnel and their families. Members, this bill reflects our collective responsibility to stand with those who protect and serve our communities. By enhancing penalties and closing existing legal loopholes, the bill strengthens our commitment to a safe Texas. Thank you, members. I'll defer to witnesses for questions and request the right to close.
Okay, stand by, because we don't show any witnesses. I need to recognize that Mr. Wu is present. Thank you, Vice Chair Wu. Members, any questions for Mr. Harris? If not, anyone here to testify for, against, or on Senate Bill 1980? Seeing no one, Chair recognizes Representative Harris to close.
Thank you, Mr. Chairman. Members, I close.
Thank you, Mr. Harrison. We'll leave Senate Bill 1980 pending for now. Next, Mr. Cook, are you ready on yours? Okay. Any particular one you want to go first on? Okay. So the chair lays out House Bill 1896 and recognizes Representative Cook to explain the bill.
Chairman, if it's okay, can I lay it out?
Certainly.
Thank you, Chairman Smithy and fellow committee members. Senate Bill 1896 states that after an arrest for certain offenses, a magistrate can issue an order of emergency protection for a victim and a victim's family and/or household members. The purpose of the magistrate's order is to prevent the defendant from inflicting further harm on the victim after the defendant is released from confinement. The magistrate's order is criminally enforceable, and a violation of the order is a Class A misdemeanor. There are two situations in which a magistrate can issue an order for emergency protection. Number one, after a person is arrested for an offense involving family violence, sexual assault, aggravated sexual assault, or stalking, the magistrate may issue an order of emergency protection before the defendant is released from custody. Or secondly, after an arrest for an offense that involved family violence with serious bodily injury or involved the display or use of a deadly weapon, and before the defendant is released, the magistrate shall issue an order of emergency protection. Senate Bill 1896 requires a law enforcement officer to provide to the magistrate the relevant information regarding the arrested person that is necessary for the issuance of a magistrate's order for emergency protection. This information is the same information that the arresting officer's agency will ultimately be responsible for submitting to the Texas Crime Information Center database. When this information is not provided up front, it requires a magistrate to seek out the necessary information and delay their ability to issue these potentially life-saving orders. Members, I appreciate the consideration of this bill, and I'm available for any questions, and I'd like an opportunity to close when appropriate. And I'm bringing this bill on behalf of Senator Huffman.
Okay, any questions for Mr. Cook? If not,
Sir, you have to clarify, this is Senate Bill 1896, not HB.
okay, I'm sorry, I think I misspoke and said this was HB 1896. It's Senate Bill 1896.
Correct.
We do have one witness who has registered. Oh, any questions? Okay. We do have one witness, Karen Diaz. Ms. Diaz, we appreciate you being here. You've registered on behalf of yourself and the Justice of the Peace and Constable Association, and you've registered for the bill, correct?
Yes, sir.
Thank you.
Good morning, Vice Chairman Wu and Chairman Smithy and committee. Good morning. Representative Cook has just about said everything that I had in my speech. Whoever wrote his little piece must have been following right behind my footsteps. So basically this is, I have the form that they fill out if y'all want to see it. I didn't know if I needed to hand that out. So basically what we're asking is for this bill to move forward. I've been a Justice of the Peace for 25 years. I'm also a municipal court judge and a Texas magistrate. It's very difficult sometimes when we are magistrating in the morning that we don't have the information, especially if a warrant is issued in another jurisdiction. If I issue a warrant in Portland and the person is arrested in El Paso and we have to do an emergency protective order, we do not have the information that we need to do that. All we see is a hit confirmation from a, sorry. Hello? It just went off. Okay. I'm pretty loud. All we have is a hit confirmation from whatever agency that warrant was issued in, so we will not have any of this information provided for us in order to issue that protective order if it comes from an out of jurisdiction. It's important to note that the victim does not have to request the MOAP. The magistrate has either the discretion or the duty to issue it. OCA was mandated last session to create standardized forms for the application and issuance of protective orders after interested parties reported that variations in the paperwork led to delays in firearm prohibition notifications and in protected party information. As a result, OCA worked with stakeholders across the state and developed comprehensive forms for use by victims, law enforcement, and the courts. I've been on the receiving end of the OCA training of these forms and am pleased to announce that we're definitely headed in the right directions. This bill would simply codify what is already a best practice, that is to encourage officers who are the first responders on the scene and in the best position to obtain the information needed from the victims to provide the magistrate with basic information about the victim and any other persons to be protected.
Thank you. Any questions, members?
Okay.
Okay, don't see, Ms. Jones has a question?
I always, my clients many times have MOABs entered against them. I didn't know the behind-the-scenes mechanisms just because I'm a defense lawyer. All I know is there's a MOAB entered against my client.
Yes, ma'am.
So this information isn't already done? Because it seems like it is, so I'm just confused.
No, ma'am. So a lot of times what happens is that form, we'll fill it out when we do the emergency protective order if we have the information. It's a recommended form. That's not a mandatory form at this time. I did a training in my jurisdiction, so all of my jurisdiction uses those forms. They have a packet that they go through, but most jurisdictions don't, especially with the warrant issued out of your own county. If it's an on-site arrest, it's much easier to get that information. But if it's an out-of-jurisdiction arrest, all we have is a copy of the warrant and the hit confirmation. So we don't even have a probable cause statement or a complaint showing us what even happened on the offense. So having that filled out for us, we would have the ability to enter a MOAP at that time, because we have to do it when they're brought before us at magistration.
Oh, wow, okay, I didn't know that.
Yes,
Okay,
ma'am.
And this is what the form would look like?
Yes, ma'am.
Okay.
This is for a MOAP, which is the Magistrate's Order of
I know
Emergency
what it is.
Protection at appearance, not through the county court or district court. So, yes, ma'am.
Thank you so much.
Yes, ma'am.
Okay. Any other questions? Okay. Thank you for being here.
Thank you very much, ladies and
Yes,
gentlemen.
any-
Have a good day.
you
Sorry you
too.
didn't get any sleep.
Well, we get the good, bad news, you got up early, but the good news is you got out of here early too, so that's good. So is there anyone else here to testify for, against, or on Senate Bill 1896? Seeing no one, Mr. Cook, to close.
I close.
Okay, thank you. And with that, the chair will leave Senate Bill 1896 pending. And now the chair lays out Senate Bill 955 by Senator Parker, and recognize Representative Cook to explain the bill.
Thank you, Chairman Smithy, for the opportunity to lay this bill out. Members, human trafficking is a global crisis, as we all know, that's impacting millions of people annually, including adults and children who are subjected to forced labor, sexual exploitation, and other forms of modern-day slavery. Traffickers utilize various tactics to lure and control their victims, including recruitment from vulnerable populations, such as people experiencing homelessness, foster children, and missing children, such as runaways. In some instances, traffickers will recruit potential victims from correctional facilities while they are incarcerated, essentially targeting them while they're in a potentially vulnerable and isolated environment with limited options for escape or assistance. Senate Bill 955 enhances a criminal penalty for trafficking of persons from a second-degree felony to a first-degree felony if the trafficker, quote, recruited, enticed, or tamed the trafficked person from a correctional facility while the trafficked person was confined in the facility, close quote. This bill aims to protect vulnerable populations and hold traffickers accountable for their heinous criminal activity. Appreciate the consideration of this bill. Available for any questions. Would like an opportunity to close when appropriate.
Certainly, and anyone, I don't show any witnesses, but anyone here to testify for, against, or on Senate Bill 955? If not, chair recognizes Mr. Cook to close.
I close, Chairman.
Okay, and with that, the chair will leave Senate Bill 955 pending for now. Let's see, Mr. Cook, you were also going to lay out Mr. Leach's bill, I think.
That's correct.
So the chair lays out Senate Bill 614 by Senator Juan Hinojosa, and sponsored by Representative Leach, and recognizes Representative Cook to explain the bill.
That's a mouthful, Chairman.
It is.
Thank you for the opportunity to lay this out. The Texas Forensic Science Commission, which is also known as the FSC, is charged with ensuring the integrity of forensic science in Texas. In 2015, the legislature passed Senate Bill 1743, which authorizes the FSC to refer cases to the Office of Capital Forensic Writs for potential post-conviction relief where flawed or outdated forensic practices may have contributed to a conviction. Under current law, the FSC can only refer a case to the Office of Capital and Forensic Writs if it is the subject of an active investigation. This limitation restricts the FSC's ability to refer credible complaints that do not require further investigations due to prior findings, also to maximize the use of public resources by avoiding duplicative investigations while still ensuring potential forensic issues are addressed, and also to provide access to the Office of Capital and Forensic Writs for individuals without representation where forensic concerns already identified by the FSC are present. Senate Bill 614 updates the Code of Criminal Procedure to allow the FSC to refer not only active investigations but also dismissed complaints if they include an express reference to a previously published FSC report that addresses the same subject matter. Happy to answer any questions and would like an opportunity to close.
Okay. Any questions for Mr. Cook? If not, anyone else here to testify for, against, or on Senate Bill 614? Seeing no one, Chair recognizes Mr. Cook to close.
Chairman, I close.
Okay. And with that, the chair will leave Senate Bill 614 pending. Mr. Louderback, are you ready to go? The chair lays out Senate Bill 1372, once again by Senator Chuy Hinojosa, and recognize Representative Louderback to explain the bill.
Thank you, Chairman. Last session, Senate Bill 991 by Senator Hinojosa charged DPS with establishing a centralized crime laboratory portal to process record requests and facilitate the secure transmission of information among relevant parties, including laboratories, prosecutors, and defense attorneys. However, there's a current legal conflict in statute. Section 411-164 of the Government Code, which creates the portal, states that a defendant or their attorney is permitted to access and use the portal. Meanwhile, in Code of Criminal Procedure Article 3914, which relates to discovery, a pro se defendant may only inspect and review materials when ordered by the court, but is not entitled to electronic duplication. This discrepancy has caused confusion regarding proper access. Senate Bill 1372 resolves this statutory inconsistency by striking the defendant from Government Code Section 411-164, allowing the defendant's attorney to access a crime laboratory portal to request any crime laboratory records, and aligns this section with the obligations and intent of Article 3914. Chief Brady Mills from DPS here as a resource for us, who can answer any specific questions we may have. This bill is supported by law enforcement and passed the Senate unanimously on local and uncontested. Please reserve the right to close, Chairman.
Okay. Any questions for Sheriff Louderback? Ms. Jones has a question? No. Ms. Ramos?
How does this bill address the needs of pro se defendants who need to access this forensic evidence?
Representative, if you can ask Brady about that, he may have an answer for you.
Yes, sir.
Thank you.
Okay. Mr. Little?
Looks like it takes them away.
Yeah, so what's the answer? Like, how do they get access to it?
Looks like that's the only thing the bill does, is take those away.
Ms. Jones?
I want to say this. I work very hard in Harris County for the defense bar to have access to the file and have copies, because to have to literally take notes on entire files is craziness, and you can't prove whether somebody changed something or not. And that was more than a notion. So you're welcome to criminal defense lawyers in Harris County. I think it's a constitutional violation to not allow people who choose to represent themselves access to that information. I also believe that they should be given copies of it. It's too hard to take notes, but so I'd be curious to talk to the law enforcement.
Representative, this defendant, allowing the defendant's attorney to access a crime lab portal, request any crime laboratory records, and that sounds pretty good.
Right, no. So the defense lawyer, yeah, But I'm talking about if I decide I don't trust my lawyer and I want to represent myself, I'm entitled to confront witnesses against me. I'm entitled to see the interviews they did. I'm entitled to see what the police have gathered. This bill appears to preclude people who choose to represent themselves the ability to confront the witnesses against them and the evidence against them.
It appears to be cleaning up and aligning some statutes.
Well, we can ask our witness. Chair calls Brady Mills. And Mr. Mills, your affirmation shows that you're here as in capacity of Texas DPS Crime Lab, and you're testifying neutral on the bill, correct?
Yes, sir, that is correct. My name is Brady Mills. I'm the chief of the Crime Laboratory Division at DPS. I am neutral on the bill and here to address any questions.
So who's got a question? Ms. Jones?
So this is a bill that precludes pro se defendants from having access to evidence against them. So you're saying you don't think that, I'm just asking, what is your position on an accused person having access to whatever forensics that you guys do?
The portal is there to ensure that defense attorneys have access to all the crime laboratory records. And this bill is just aligning the language that created the portal with the existing language that's in 3914 for discovery.
I know I'm gonna get the information. I'm a criminal defense lawyer. I'm talking about specifically people charged, defendants who are charged with crimes where your office has done testing. Unless I didn't understand the bill says that the people who are actually charged with crimes, if they choose to represent themselves, do not have access to the evidence that you guys have against them. Do you have an opinion on that?
This is really just aligning the two pieces of statute to align with the intent of 3914. I do hear what you're saying about the defendant having access to the records themselves, but if you go back to 3914, the intent is to align that where the defense attorney would be able to get those records.
But there's no defense attorney, so I'm specifically, I don't, like, I'll put it on the shelf that they're attempting to align something. I'm concerned about people who are charged with crimes having access to evidence that will be used against them.
Mm-hmm.
Do you have an opinion on that? Not about the aligning, whether I decide to represent myself, you guys have done analysis that presumably either inculpates me or is exculpatory regarding to me. What rights do I have? I mean, I know you're saying you're neutral, but I'd like an answer.
Again, neutral on the bill, but I do hear what you're saying about access to records. And I think our efforts are to ensure that the portal is there to provide records. But with the constructs that are already there, we are aligning it to have the defense attorney to have access to those records.
So you're neutral on whether the defendant has access?
That's correct, yes, ma'am.
Okay, thank you.
Okay. Any other questions? Okay. Thank you, Mr. Mills.
Thank you.
Anyone else here to testify for, against, or on Senate Bill 1372? Seeing no one, Mr. Louderback, you want to close?
Members, this is prefers to be a simple cleanup bill, and I request favorable consideration. With that, I close.
Okay, thank you. So with that, the chair will leave Senate Bill 1372 pending. Next, the chair lays out Senate Bill 1936 by Senator Chuy Hinojosa and recognizes Representative Louderback once again to explain the bill.
Thank you, Chairman. Controlled Substances Act defines an abuse unit penalty group 1A substance such as LSD based on how the substance is applied to the carrier medium, typically a blotted paper. If the paper is perforated or marked, each individual square is considered one abuse unit. However, if the paper is not perforated or marked, the law defines an abuse unit as as each quarter-inch square section of paper, requiring labs to manually measure and count the dimensions of the sheet. This approach introduces inconsistency in lab analysis and can complicate prosecution, as officers and forensic experts must estimate dosage units based on the physical size of unmarked paper. Senate Bill 1936 amends the definition of an abuse unit using a weight-based standard. The bill replaces the existing language that references square dimensions with a new threshold of 10 milligrams of paper when the carrier medium is unmarked or unperforated. This change brings greater scientific precision to the statutory definition, which supports more consistent lab analysis and aids law enforcement in the prosecution of LSD-related offenses. Again, we have Chief Brady Mills from DPS here as a resource witness. It was supported unanimously by law enforcement and local and consent calendars in the Senate. Reserve the right to close.
Okay, any questions for Mr. Louderback on this? Okay, seeing none, the chair calls Brady Mills once again. And Mr. Mills, once again, you are here as in your capacity as Texas DPS Crime Lab Chief, and you are neutral on the bill.
Yes, sir, that is correct. Brady Mills, Chief of the Crime Laboratory Division, DPS, here as a resource on the bill. If there's any questions, I'd be happy to address those.
Ms. Rodriguez-Ramos?
So it's, the LSD is on a paper and it's perforated, they sell each one like little square. And what this is saying is they're gonna measure the same, use the same measurement, whether it's 10 squares or 1 square per unit.
It's moving it to a weight-based for a penalty. So when they're perforated, it's very easy for laboratories and for law enforcement to understand how many abuse units there are. But a lot of times, we'll have evidence that it's not perforated. And so then we have to go to a measurement process. And to take the potential inconsistencies out of measuring, we're asking to see if it would move to a weight-based offense.
And the weight is depending on how much LSD might be on in that paper. Like, could it be less LSD that they put in that paper?
It would be the weight of the entire item.
Okay, and so the weight is not the weight of the paper, but it's the weight of the substance that is in the paper.
It's the weight of both. We would weigh the actual material.
Yeah, but what I'm saying is, what if the weight of the paper is more than the actual substance?
It's what we do with all the adulterants and dilutants are part of the weight in controlled substances, and so this aligns with that.
Okay, all right, thank you.
Any other questions? Okay, once again, thanks, Mr. Mills, for being
Thank you,
here.
Mr. Chairman.
Anyone else here to testify for or against or on Senate Bill 1936? Seeing no one, the chair recognizes Representative Louderback to close.
I close.
Okay. With that, the chair will leave Senate Bill 1936 pending. Mr. Schatzline, you ready?
Yes, sir.
Okay, the chair lays out Senate Bill 2580 by Senator Hancock and recognizes Representative Schatzline to explain the bill.
Thank you, Chairman and members. Thank you for the opportunity to lay out Senate Bill 2580. SB 2580 is a clear, narrowly tailored public safety measure that amends Article 18B.0014 of the Code of Criminal Procedure. This bill expands the categories of law enforcement agencies that are authorized to independently use tracking equipment and access certain communications. They're tools that are essential in time-sensitive emergency and criminal investigations. Under this existing law, only sheriff's departments and counties with populations exceeding 3.3 million are authorized to independently utilize this technology. In practice, this threshold means that only Harris County currently qualifies. And so SB 2580 addresses this issue by lowering the population threshold to 500,000, therefore extending this authority to sheriff's departments in other major and fast-growing counties. This would actually go to our largest 12 counties if this were to pass. These are high-need jurisdictions facing complex public safety threats, yet their sheriffs must currently rely on DPS or other outside agencies to act, adding delays that can have life or death consequences. My Sheriff Bill Wayburn in Tarrant County recently shared a story of an abduction of a 3-year-old little girl in Tarrant County, and although law enforcement quickly identified a suspect and phone number of that suspect, the current law prohibited the Sheriff's Department from acting directly and swiftly. So they had to locate a DPS officer and obtain authorization for a ping, delaying the investigation until the suspect had crossed state lines into Oklahoma. Luckily, they were able to find a way to get that suspect to come back across state lines. But in the words of my sheriff, and I think this is incredibly important, minutes and seconds matter in these cases. So we should not be restricting sheriffs and counties with millions of residents simply because they fall below an outdated and arbitrary population threshold. I welcome any questions and respectfully reserve my right to close.
Okay, any questions for Mr. Schatzline? Okay, thank you. I'm sorry, Ms. Jones.
So basically, you're trying to, it used to be local, for say with Harris County, and now you're just trying to get more law enforcement into that pool?
Yeah, so essentially, like right now, what Tarrant County Sheriff's Department has to do is they either go through DPS. If they can't access DPS in time, they'll go through a local municipality that's 200,000 or more. But the issue is, like right now, if our Tarrant County Sheriff's Department couldn't access DPS in time to get this particular suspect, they would have to go through Fort Worth PD. But if Fort Worth PD had a delay, they would kind of have their hands tied. And so the other side is, what this would do is if they have access to the technology, they also take on liability. And so right now, Fort Worth PD is liable for what happens if Tarrant County Sheriff's Department uses their technology. And so this kind of just puts it all back on the Sheriff's Department, and I think it's going to make it go a lot faster. It does not change the procedure for them having to go through the courts, make sure that everything is there. This bill quite literally just takes it from 3.3 million to 500,000.
Okay, thank you.
Thank you. Any other questions? Okay, thank you. Mr. Schatzline, stand by, and I will ask if there's anyone here to testify for, against, or on Senate Bill 2580. Seeing no one, Representative Schatzline, you can close.
Thank you once again, Mr. Chairman and members. In closing, SB 2580 ensures that more sheriff's departments have timely access to critical investigative tools when lives are at risk. It is a common sense update that modernizes the law while maintaining appropriate safeguards. I ask for your favorable consideration of this bill, and I close.
And so if there's no objection, any more questions? If not, if there's no objection, the chair will leave Senate Bill 2580 pending for now. Thank you, Mr. Schatzline. I need to recognize that Ms. Bowers is present, and also the chair lays out Senate Bill 1937 by Senator Chuy Hinojosa, and recognize Representative Louderback once again.
Thank you, Chairman. Currently, the state is required to perform DNA testing of biological evidence prior to trial in any capital case where the death penalty is being sought. While this ensures that testing is conducted early and at no cost to the defense, the law does not include the advice of a subject matter expert from the laboratory performing who could provide valuable information regarding the viability of any biological evidence. As a result, evidence that is unlikely to yield a usable DNA result may still be submitted for testing, leading to unnecessary use of limited forensic resources, increased costs, and delayed turnaround times. Including the laboratory expert in the pretrial process would provide valuable scientific insight and help streamline the identification of viable biological evidence. Senate Bill 1937 requires the court to include a subject matter expert from the accredited laboratory, which will be used to test the evidence to meet and confer with the attorneys as part of the pretrial process. The defense and prosecution are already required to confer about biological materials used in a capital case. Including the lab expert in this process will help streamline capital cases. Once again, I have Chief Brady Mills from DPS here to, as a resource witness who can answer any questions.
Okay, and the chair
Reserve the right to
okay,
close.
I'm sorry. Any questions for Mr. Louderback? If there are none, the chair calls Brady Mills. And once again, you are Brady Mills here on behalf as Division Chief of Texas DPS Crime Lab, and you're neutral on the bill, correct?
Yes, Mr. Chairman. Committee members, Brady Mills, Texas Department of Public Safety Crime Laboratory Division. Happy to address any questions.
Okay, any questions for Mr. Mills? Okay, thanks once again for being here.
Thank you, Mr. Chairman.
Anyone else here to testify for, against, or on Senate Bill 1937? Seeing no one, the chair recognizes Representative Louderback to close.
Members, this bill streamlines capital cases and I request favorable consideration. With that, I close.
Okay, and so if there's no objection, the chair will leave Senate Bill 1937 pending. Mr. Little, you ready to go?
I am.
Okay. The chair lays out Senate Bill 2798 by Senator Creighton and recognizes Representative Little to explain the bill.
Thank you, Mr. Chairman, members of the committee. Laying out Senate Bill 2798. This bill is extremely simple. All it does is extend the statute of limitations for certain financial crimes. Currently, the statute of limitations for financial crimes under Chapter 32 of the Penal Code is limited to 3 years. If you compare that to the civil side, we have a statute of limitations of 4 years from the discovery of the violation. This bill proposes to extend the criminal statute of limitations to 7 years because certain of these crimes are inherently difficult to discover. And that's all the bill does.
Okay, any questions for Mr. Little? We do have a witness. Oh, Ms. Jones has a question.
I'll wait till after the witness.
Okay. So if there's no other questions, the chair calls Carmen Morales. And Ms. Morales, your affirmation shows that you're Assistant District Attorney. You're here on behalf of the Montgomery County District Attorney's Office and yourself, and you're for the bill, correct?
That's correct, Chair. Good morning, committee members. My name is Carmen Morales. I am Assistant District Attorney with Montgomery County. I represent my elected official, Mr. Brett Ligon. The very nature of fraud is that the perpetrator's bad conduct makes any fraud difficult to discover. Victims often do not realize they have been defrauded until well after the offense occurs, and only then do they report it to law enforcement. The statute of limitations clock begins ticking at the time the crime was committed and not at the time that the crime was discovered. These investigations are time-sensitive and frequently require lengthy investigations, as law enforcement agencies are commonly tasked to obtain voluminous records from financial institutions, both in and out of state. Not to mention that these investigations often lead to the discovery of multiple victims. Under our current law, there is an arbitrary application of the 7-year statute of limitations. For example, some offenses like credit card or debit card abuse are afforded the 7-year statute of limitations. This covers our financial institutions. However, the offense of fraudulent use or possession of credit card information is only given a 3-year statute of limitations. What this translates to is that if a perpetrator steals someone's credit card and uses it, the state has 7 years to bring an indictment. Presumably, in those cases, the victim would know that their credit card was used. By contrast, when a citizen is the victim of fraudulent use or possession of credit card information, that is, someone steals their identifiers, opens counterfeit credit cards, debit cards, the victim may not learn of this until it affects their credit score or via some other accidental discovery. In those cases, as the law stands today, there is a 3-year statute of limitation. Senate Bill 2798 seeks to close this gap and afford our citizens the same protection that we currently afford our financial institutions. Thank you.
Thank you, Ms. Morales. Any questions for Ms. Morales? Ms. Jones?
Your testimony actually cleared it up for me. It actually makes sense to me.
Thank you, Ms. Jones.
Any other questions? See, it was worth the trip.
Worth the trip.
Okay.
Thank you so much.
Okay, thank you for being here. Is there anyone else here to testify for, against, or on Senate Bill 2798? If not, Representative Little, if you want to close.
I close.
Okay. And so if there's no objection, the chair will leave Senate Bill 2798 pending. The chair, Mr. Little, will also be laying out this bill. It's the chair lays out, or will be explaining this bill. Chair lays out Senate Bill 1099 by Senator Flores and recognizes the sponsor is Representative Hefner, and the chair recognizes Representative Little to explain the bill.
Thank you, Mr. Chairman, members of the committee. Laying out this bill for Representative Hefner. Crisis at the border has caused increases in crime throughout the state. Citizens and non-citizens often face the same punishments for equal crimes. Senate Bill 1099 addresses the issue of criminal offenses committed by illegal or unauthorized aliens by increasing the penalties for such offenses. Specifically, the bill amends existing laws to ensure that if a defendant is found to be an illegal or unauthorized alien at the same time of committing a felony offense, the punishment is elevated to the next highest category of offense.
Okay, any questions for Mr. Little? Yes, Ms. Rodriguez-Ramos.
Mr. Little, in the bill, it allows a jury or a judge or a jury to determine that the defendant was undocumented at the time of the offense. How is, it's very nuanced immigration in the application and the statuses, so how are we to expect that a judge or a jury will be able to know that that is the case? So
Yes.
go ahead.
Yes, Representative Ramos, I understand this is partially, or in part, your area of practice, and these can be very nuanced fact findings. So I think it would probably require either government or expert testimony to determine whether that person was present and legal in the United States at the time.
Yeah, but so the bill doesn't say that it needs additional expert testimony, and so it could be any court saying, and the jury says, oh, yeah, he looks illegal because you don't speak English or whatever, right? Like it's a DACA person, so there's a big gray area.
Yes, Representative Ramos, I am assuming for sake of argument that it's going to require the jury's belief on that finding by beyond a reasonable doubt, like every other aspect of the offense.
Right, but we don't, they could find beyond a reasonable doubt without any additional expert testimony, essentially. I mean, it depends on the court, right, and who's making those decisions, who they want to bring in to really clarify that.
It's possible.
Yeah, it sounds really bad. Okay, all right, thank you, sir.
Thank you.
Ms. Jones?
I know you're laying this out for Chair Hefner, but I think that to omit that it requires like some kind of expert testimony is scary to me, because there are people that just have anti-immigrant hate, and they don't think any immigrants should be here, documented or otherwise. And so I would be afraid to not have some kind of objective guidance on that issue.
That makes good sense, Representative Jones. I'm sure Representative Hefner would be open to listening to that.
Okay, thank you.
Any other questions? If not, we do have a witness. The chair calls Daniel Woodward. Mr. Woodward, your affirmation shows that you're here testifying on behalf of Texas Civil Rights Project and you are against the bill, correct?
That's correct. Good morning, committee, Chair Smithy, everybody. So my name is Daniel Woodward, and I'm a policy attorney with the Texas Civil Rights Project in opposition. And I oppose this bill because we oppose treating people differently based solely on their immigration status, especially in the criminal justice system. It is entirely inappropriate to raise state criminal penalties based on immigration status alone. Immigration is a largely civil body of law that Congress did not intend to map onto state criminal penalties. And adding time to a state crime based on immigration status is precluded by federal law because it amounts to adding punishment for federal immigration violations. In some areas of law, states are of course welcome to supplement federal crimes, but immigration is an area that courts have repeatedly said is the sole prerogative of the federal government because in part, our nation will not have a united foreign policy if 50 states have 50 different immigration laws. Furthermore, it's going to be costly, time-consuming, and difficult to put immigration status into the hands of local magistrates, judges, and juries, as Representative Ramos was pointing out, especially when the definition includes people who, in some cases, may have protection under the federal immigration system. Federal immigration judges have years of training to make these complex determinations, and it is all that they do. And our courts will get bogged down if they have to spend time making these kinds of determinations. And I just want to ask a hypothetical of what would happen if a person was found by a jury to be deemed an illegal alien under this law, and then like a year later, they won their case in immigration court. Would they be able to go back? Would they, I don't know what would happen in that case. So that's the big picture reason why we oppose this bill. Thank you for your time today.
Okay, thank you. Any questions for Mr. Woodward? Okay, Ms. Jones?
A quick question. Can you cite the law that says that immigration is the exclusive purview of the federal government?
The leading case is United States v. Arizona, or Arizona v. United States. I always flip it.
Okay, thank you.
Yes.
Any more questions? Okay, thank you for being here. I'm sorry, Mr. Wood.
Thank you. I'm not an immigration attorney, but I did start my practice helping out my dad in his immigration practice. One of the things that I realized from that is half the times immigration doesn't even know what immigration status someone is. Like they're confused on their own records, and they have their own records that are conflicting with other records that still conflict with their records, and like somebody who is ordered to be deported also has two other orders from court saying you're not supposed to be deported, and nobody knows what's heads or tails, and we spend the next 6 months trying to sort it out.
Yeah.
Is that about right?
That's about right. And one point that I've been thinking about with this bill is it says failed to maintain or attain or maintain lawful status. But I think something that we don't think about much is that immigration status is not static, and that people change immigration statuses. They might be on a visa one day and then that expires, but then they might get some kind of new status. And I think that this bill does not account for that.
And that's actually was my cousin. She was here for medical school. She's already a doctor in China, and she's coming over and needed to go through the process to finish her license. And while she was in her residency, she forgot to renew her application, and it expired for like 6 months. And so during that time, she would have been right here.
I think worse than that. Under this bill, she would continue to be an illegal alien even after she got status because she did not maintain her status. So that's an excellent point, Chairman.
And now she's an American citizen with a United States medical degree and then practicing in Ohio. So, I mean, and it's not just Arizona v. U.S. That's also like the impetus of saying that states don't have a right to deal in immigration. It's also just flatly the Constitution of the United States, correct?
Yes, that's right.
Like Article 10th Amendment says like anything that's enumerated, that's in the powers of the federal government enumerated by the Constitution, like black letter law says states may not touch.
Yes,
Right.
that's right.
Okay. I think like the biggest thing that I think the general public just doesn't understand, and probably the legislature doesn't understand, is like immigration is not like one simple thing. It's not an on or off switch. It's a really complicated gray area, and everyone's opinion throughout the process of where everything is changes on a moment-to-moment basis. Is that fair?
That's absolutely correct.
Okay, thank you.
Any other questions, members? Okay, thank you for being here, Mr. Woodward.
Thank you. I appreciate it.
Is there anyone else here to testify for, against, or on Senate Bill 1099? If not, the chair recognizes Mr. Little to close.
Close.
Okay, Mr. Little closes, and if there's no objection, the chair will leave Senate Bill 1099 pending. Ms. Thompson had asked me to lay out her bill. Chair lays out Senate Bill 1278 by Senator Parker. The sponsor is Representative Thompson, and it relates to an affirmative defense for prosecution of victims of trafficking of persons or compelling prostitution. And remember, it's real simple. What it does, in the prostitution chapter 8 of the Penal Code, this creates a new section 8.09, which creates an affirmative defense to prosecution for prostitution. That's not easy to say. Prosecution for prostitution if the actor was a victim of an offense under 20A02 or 4305. In other words, if the person was who is charged is a victim of human trafficking. So if the victim is being forced to engage in prostitution by the trafficker, that would constitute an affirmative defense to the prosecution. I'll be glad to address it. We have a couple of witnesses. But
Chairman,
Yes.
as I understand this is if you are being trafficked and you traffic someone else, that is an affirmative defense under this bill. Isn't that what it is?
I think so, yeah.
Is that a good thing?
I think
Mr. Wood?
I think this has been the fight about. I mean, this is like I think the third or fourth session I've looked at this bill, and it's every time. So I mean, we're trying to find that balance point. Like you're trying to cover people who were brought into the trafficking scheme unwillingly, but then sometimes those people transition into
A trafficker.
a more willing, like. You know, you can say they've been brainwashed, and that's. I'm not saying either way. I'm saying that that's the other side is. That's what the other side is saying is like. Well, some of the people that you would be exempting in this would be people who might have one time were brought involuntarily, but now they're more voluntary than before. It's there's still this arguments about like, hey, even if they're more volunteer before, they would not be in that situation, but for them being forced to be in that situation in the first place, and now they've been brainwashed, and they're now a more willing accomplice. I understand the arguments. I'm not sure I agree with all of them, but that's what they are.
Thank you.
Ms.
Thank you,
Jones?
Vice Chair.
Once upon a time, there was a 14-year-old girl that got, back then they called her a prostitute. She literally was trafficked, and she was my aunt. I'll jump to the end of the story. She was murdered in 1984 by her trafficker. They called them pimps back then. Because my aunt was 14, she was a kid, my grandfather kicked her out because she got pregnant. They didn't talk to her about the birds and the bees. She ended up getting pregnant, and they didn't want for her pregnancies to corrupt the kids who were under her. So they put her out in the street, and she got trafficked. Most of the things my aunt did, she did to survive. And if you are I don't want to use street language, if you are the one that the trafficker feels is the favorite for the bottom, right?
You run other.
They make you do stuff, and you just don't know. Especially if you're a kid, it's all you know. As parents, the reason that we teach our kids stuff is because if we don't teach them, somebody who doesn't love them may. So even if a traffic victim becomes a trafficker, you are presuming that they know what goes on the outside world. It's no different than people who grow up in the hood and they literally never leave their neighborhoods. They don't know other ways to think. They don't know what they don't know. And so, and my aunt struggled to get out of that situation. And unfortunately, my grandfather did not understand that situation because he thought that she should know better, even though they kicked her out when she was a kid. And the thing I remember the most about my aunt, so she had to shoplift in order to feed herself and her kids. And she had just gotten out of jail, and she was tired. I think my aunt was 32 when she was murdered, shot twice in the head. She had come to my grandparents. She just wanted to live there. She was able to get away from her trafficker, and my grandfather wouldn't let her come live with them again because he didn't understand. 2 days later, she's murdered. So I'm just telling you, if you're a trafficking victim, you are not taught stuff like we as parents would teach our kids.
Sure.
And I'm getting emotional because my aunt's life was just effed up from the start the second she got kicked out of the house by my grandfather. And as a practical matter, my cousins who were her kids, they've all had effed up lives because they were living from pillar to post. And so if you're a victim, they shouldn't be held to the same standards as other people because they're victims.
Thank you. It's good insight.
And I do think it's significant, Mr. Blow, that it's an affirmative defense as opposed to an exception to prosecution.
Yeah.
But we've got a couple of witnesses. They can talk about it. First, the chair calls Ross Jackson. Mr. Jackson, your affirmation shows that you're here on behalf of the Texas Public Policy Foundation testifying for the bill, correct?
Yes, sir.
Thank you.
Good morning. My name is Ross Jackson. I'm with the Texas Public Policy Foundation. Thank you, Chairman and committee members, for listening to my testimony today in support of SB 1278. I want to thank Senator Parker and Rep. Thompson for all their work on human trafficking legislation and this bill in particular. In 2023, the Human Trafficking Hotline identified over 1,700 victims of human trafficking in Texas. Nearly 80% of these were women, and nearly 250 were children. While the Texas Department of Criminal Justice does not publish data on incarcerated individuals suspected to be victims of trafficking, research surveys by advocacy groups indicate that nearly 1 in 4 incarcerated women have been trafficked or coerced in committing sexual acts in exchange for necessities. Additionally, a 2024 Department of Justice report found that 91% of girls in our secure facilities, NTJJD, showed clear or possible concern for sex trafficking. Women and minors throughout the state are routinely prosecuted and incarcerated for crimes they committed while being trafficked. This has been acknowledged by the governor, who established a clemency program in 2020 for survivors. This has been an incredibly valuable tool in assisting victims that have already been prosecuted. Creating a human trafficking specific defense could prevent unjust prosecutions on the front end, avoid the waste of legal resources, and mitigate the negative effects of convictions on a victim's recovery and rehabilitation. Most states have some sort of affirmative defense for human trafficking victims. Many states, including Oklahoma and Wyoming, have broad affirmative defenses specific to human trafficking victims that have been applauded by advocacy groups. Texas's current legal protections afforded to victims do not prevent their unjust prosecutions. SB 1278 would require victims who raise the defense to prove that their crimes were committed as a result of their victimization, and that a reasonable person would commit the offenses because of coercion, duress, or threats against them or their family. That concludes my testimony. Happy to answer any questions.
Thank you, Mr. Jackson. Any questions? Ms. Jones has a question. Sorry.
Would you liken the mentality of a trafficking victim to like domestic violence on steroids?
I think that's a fair.
And I bring that up to say this. If you know anything about domestic violence, which I'm a survivor of domestic violence, very lucky to be alive, it takes domestic violence victims at least 7 times on average to escape their abusers.
Yes, ma'am.
Because of the psychological power and control wheel, the cycles of abuse. I would encourage all my colleagues to go Google those 2 things. And people, and it's blaming the victim. I remember with my aunt, everybody called her a prostitute. And she wasn't. And the only thing she literally knew how to do, the only thing she controlled was her body. It was the only way she could make money. And that's what she was taught, and she didn't have a choice. I mean, when she tried to escape to my grandparents, her trafficker found her, and 2 days later she was dead. So it's real, because they're expendable to the traffickers. And they know they're expendable to the traffickers. You'd be surprised at what you do in order to survive. Or especially if you have kids, to feed your kids. And to give your kids a shelter over their head. In any case, thank you for testifying.
Thank you, ma'am, for sharing your story.
Mr. Little?
Ross, I think I backed my way into this. I want to be sensitive to Representative Jones and her story. As I'm looking at this, I want to make sure I understand it. And I think this is the reason I would support this bill. It sounds like there has to be a chain of causation, that the trafficking offense has to have been coerced by the person who trafficked you. So I'm not explaining this well because it's hard for me to articulate, but I'm going to try to explain this in the way that I understand it. If I traffic Joe, it's going to be as a result, in order for me to have an affirmative defense, I must be coerced by the person who trafficked me. So there has to be a daisy chain, for lack of a better word, between the person I'm trafficking and the person who trafficked me. It seems like it's got to be one criminal enterprise, for lack of a better framing. Am I describing that accurately for you?
Thank you for your question, Representative Little, and I think I understand what you're saying. In my research, what I've come across is I think we're talking about the same thing, and it's a nexus requirement that the crime be directly committed to the trafficking offense.
So I think where I got okay with it is you look in A, it says it's an affirmative defense to prosecution. The actor was a victim of an offense under trafficking, who engaged in the conduct charged because the person who committed the offense of which the actor was a victim coerced the actor. So as I'm reading that, there's a daisy chain between the person who trafficked me and the person I'm trafficking as part of one criminal set of acts.
I think I understand. Like,
Is that how you read it?
to raise this defense, a victim of trafficking must demonstrate through evidence that they were a victim of trafficking by this person in order to excuse themselves.
Yes, I think in order for me to enjoy the affirmative defense, it's got to have been someone who trafficked me so that I can traffic someone else as part of one collective crime.
So, Representative Little, this bill is not specifically tailored to the crime of trafficking another person either. This is an affirmative defense that can be applied to a person that, say, while they were being trafficked, they were forced to sell drugs or committed theft.
That's not how I read that.
Okay.
Now I've got to think about this a little harder. I'm sorry.
Any other questions? Thank you, Mr. Jackson, for being here.
Thank you.
Chair calls Amber McCray. Ms. McCray, your affirmation shows that you're here on behalf of Street Grace, and you are for the bill, correct?
Yes, sir. Good morning, Chairman and committee members. Thank you for being here, and a special thank you to Representative Jones for your heartfelt personal account. I know that was truly difficult to share. My name is Amber McCray, and I'm the Director of Outreach for Street Grace, Texas. Street Grace is a national nonprofit dedicated to ending commercial sexual exploitation and human trafficking. We have offices of 5 states, including right here in Texas. As a survivor-led organization, we are also always going to advocate for policy that prioritizes the safety and well-being of victims of this horrible crime. Hence the reason I'm here today to testify in support of Senate Bill 1278. An affirmative defense for trafficking victims is crucial because it prevents the criminal justice system from punishing individuals for actions they were forced to commit by their traffickers. Trafficking victims often engage in illegal activities, not of their own free will, but under coercion, threats, and manipulation from their exploiters. The same force, fraud, or coercion that traffickers use to control trafficking victims into being sold is also used to compel them to commit many other crimes. Then, in a vicious circle, the risk of prosecution for those offenses is used to tighten the control, leading to an ever-widening circle of injustice. Without an affirmative defense, these victims can be prosecuted and convicted for crimes that are a direct result of their victimization, compounding their trauma and perpetuating injustice. Traffickers often rely on sustained manipulation, dependency, and fear rather than just imminent violence to control their victims. So current defenses are not sufficient enough to prevent injustice. Traffickers, once they've gained sufficient control over their victims, will often begin to use them as more than an object to sell in the commercial sex trade. They will begin to use the same victims to move drugs or commit other financial crimes. Too often we have seen women who are being sold nightly, charged with robbery, and their traffickers tell them they don't have to sleep with the next guy, they can just take his money and leave instead. Senate Bill 1278 would aid in obtaining true justice because it would increase the number of trafficking victims who are willing to testify about the complete range of crimes their traffickers were responsible for committing.
Okay, thank you, Ms. McCray. Let me ask you a question, just kind of how this works in practical application. For a young lady, or assume it's a young lady, to avail herself of this defense, if she's got a lawyer, she's going to have to tell the lawyer, I was being trafficked. And the next question is, well, who was trafficking you? So she's going to have to identify her trafficker.
Correct.
Now, that could result in 2 things. It could be in the trafficker actually being caught and prosecuted at that point, or it could put the young woman in substantial danger from the trafficker if she were to basically turn him in and you wouldn't get a successful prosecution on it. Any comment on that?
Yes, I think at the end of the day, though, these young women are in danger anyway. And we have got to do something that allows them to be more willing to open up about what is happening to them. And this affirmative defense would be a step in that direction.
Okay, but would it be an assist or an aid if the lawyer said, okay, you can plead guilty to this, your first offense or whatever, and maybe get a little jail time, maybe pay a fine, which probably the trafficker would pay, or if you want to get out of this, you can identify your trafficker in court. Would that help kind of end some of this abuse, do you think?
Well, I think the problem with them pleading guilty, even if it's a minimal, time, is that that's now on their record. And these crimes are affecting these women as they are trying to get out of the life, as they are trying to rebuild and start over. Those types of things on their record can drastically hinder the types of employment that they're able to receive, where they can live, and different things like that. So we have to do more than what's currently
So
on
they
the
get
books.
themselves in a box and there's no way out, yeah,
Correct.
at that point. Okay. Ms. Jones?
Mr. Chair, I'm going to have to respectfully disagree with a couple of things that you said. The first thing I'll say is that sometimes the women don't know. Like, all they know is I've got to, I don't know, steal a man's wallet when I'm with him or whatever, because if I don't give my trafficker the money, then I know something's going to happen to me. That's all she knows, especially like in the event in the situation with my aunt, who was 14 when she got snatched into that world. So that's the first thing I think, just again, based on personal experience. Also, so I think it's going to take more with the defense lawyer understanding that world, right? So I've fought my entire career to, even in talking with prosecutors, like they think that it's that she's consenting to being sold. They think she's making a decision to do something, and she's not. Right? And to your point, Ms. McCrae, you get one thing on your record, it affects everything else. And trust and believe, if you have family, the victims know that their trafficker knows who their family is, and they threaten the family. That's just what they do. And I also don't think that just because you're not in the eyesight or earshot of the trafficker, if you do something, if you have been brainwashed, very much like Patty Hearst was, I'm telling my age, that you, I don't remember what the syndrome is called, but Stockholm syndrome, where you effectively become them. And so there's a bunch of, I don't know what you call de-brainwashing, that you have to teach them. Just even in my defense work, when I'm speaking with victims of human trafficking, like they'll think that they have some kind of power when they're the bottom, right? When they're the favorite of the trafficker. And that's all they know. So they literally adopt that way of thought, because now they're not getting beat as much, they're not getting punished. And then the trafficker actually brainwashes them to control the other trafficking victims. And it literally is a mode of self-defense to become the next abuser. So anyway, but thank you.
Thank you, Ms. Jones. Any other comment or question? If not, thank you very much for being here, Ms. McCrae.
Awesome. And to say, in conclusion, we just, again, strongly support Senate Bill 1278. Without it, the legal system risks punishing the very people should be protecting. Thank you for your time.
Thank you very much. Is there anyone else here to testify for or against or on Senate Bill 1278? Chair hearing none. Chair recognizes Mr. Little to close.
It's your bill, isn't it?
It's my bill, okay. It's not really my bill, but I close.
I have some questions.
So, yes, Mr. Little.
So I'm wrestling with this because I absolutely see what Representative Jones is saying. I'm also struggling with it being an affirmative defense to murder. Like, I think there are certain circumstances. Well, it would be nice if we had the ability to mitigate the impact of an offense as opposed to it being purely an affirmative defense, like just out of hand. Like you you go to trial and you cannot be punished for murder if you're able to demonstrate this coercive effect. I understand mitigating it. I'm not all the way there with it being an affirmative defense to prosecution on anything. And I don't, maybe Representative Jones has feelings about that or thoughts.
As usually, we can intellectually joust about it.
Sure.
Yeah. And so you might get with Representative Thompson, also Senator Parker, and see if there's some,
Of course.
some
Thank
way
you.
to tailor this. Mr. Verdell?
Thank you, Chairman. I just got here late, so I apologize. I missed some of the discussion, but.
I don't know. if
Oh,
you-
well, I'm sorry, I just came back in. I've already been recognized for being here. What's wrong with the current law, if you don't mind me asking, compared to what this does? Does the current law not
Current
do
law-
enough?
Yeah.
Okay, copy that. That answers it. Appreciate it.
Any other question? If not, we close, and the chair will leave Senate Bill 1278 pending. The chair now lays out Senate Bill 127 by Senator Hall and recognizes Representative Money to explain the bill.
Did you say 127?
Yes.
Okay.
You realize you're still on the committee, don't you?
Yeah, no.
Okay.
I was trying to lay out a bill in a different committee, but I have a layout for a different bill than 127.
Is that right?
Right, don't lay this one up there. I've got it on the computer.
Okay. I'll lay it out on the flies. This is
I know.
It is. Let me put it on.
You need a copy of the bill? Hey, Mr. Money, you want a copy of the bill, or is that going to be
Got
adequate?
it.
It's actually very, very simple. It just extends the statute of limitations on reporting child abuse.
Yes.
And I apologize, we kind of rushed you into this, so.
No, it's no problem at all. If I'd been handed the right bill in the first place, I would have been okay.
We're here for you.
Thank you, Mr. Chairman and members. This is a bill by Senator Hall that lengthens the the statute of limitations for child abuse.
Well, reporting child abuse, right?
Reporting child
Yeah.
abuse, hold on. Yeah. Somewhere. I'm really sorry.
Don't they give you stuff to read?
Huh?
Just read the thing they gave you to read.
They didn't give me a thing to read. That's the problem, is that they gave me.
That's a dead bill.
Yeah.
Well, let me help you just a little. I actually had
Thank
looked
you. I
at it.
apologize. I was handed
Okay.
the layout for 1980.
We put you in kind of a difficult situation here. By the way I understand the bill is that it's a felony not to report, to intentionally hide child abuse or to conceal it. And it can be it can be a Class C misdemeanor if it's, or Class A misdemeanor, I think, under some circumstances.
Yes.
And so this bill would simply increase the statute of limitations for a prosecutor filing that action against, that's the way I understand the bill.
Yes.
So, okay.
Yeah, it currently failure to report child abuse or neglect is a Class A misdemeanor unless it is an intentional cover-up, in which case it's a state jail felony. So the current statute of limitations for this crime is either 2 or 3 years, depending on whether it's the Class A or state jail felony. This bill would increase the statute of limitations to 4 years after the action is discovered in cases where it's categorized as a felony, meaning that the abuse was intentionally concealed, and increases the statute of limitations to 3 years after the action is discovered in cases where it is a Class A misdemeanor.
Any questions for Mr. Money? Mr. Verdell has a question, I think.
Can you go into a little more detail on what? No, I'm just kidding. Never mind.
That's all right.
Ms. Jones has a
I
question.
think I'm oriented now.
You know what, I will speak with the bill's author, because I know this isn't your bill, and you were struggling, and we helped you out.
It is mine. I just, I've been preparing this morning for a different Senate bill by Senator Hall. That's just a failure on my part, but I'm familiar with this bill. What you got?
So how do I know? I guess I'm trying to figure out, once you know that they've intentionally hidden the neglect or abuse from I'm confused how you know if it's intentional.
Mr. Wu has a question.
Can I help out?
Comment.
Of course you may.
Do you mind? So this is something that we've looked at for a while because I work in the CPS realm too. So again, there is an affirmative duty for people to report child abuse, and there is a increased affirmative duty if it is, I think, sexual abuse. For professionals, for anyone who's basically licensed, for teachers, for lawyers, it's a mandatory reporting. You don't have a choice. So there's times when I've interviewed kids in juvenile detention, and they said to me, hey, yeah, so-and-so did this, and, so-and-so gave me drugs and whatever else, and I tell them I have to report that. That's child abuse, that's abuse and neglect. And I tell them I have to go report this in the DFPS reporting. Some people don't do that. Some people sit on information. So we had, we've had, I don't know, last session and a few sessions ago, I've had this bill basically that would create an offense if you told witnesses to don't say anything, you move the perpetrator around. This is basically leftovers from the Caroli Ranch, right? Where Dr. Nasser was molesting and raping girls for decades, and they told the families, hey, if you say anything, we'll take you off the team. If you do this, we'll do that, right? And so, did they know that it was happening? Did they see it? Probably not, right? They didn't see it, but enough people came to them and said, hey, this is going on. And part of that is if you have information that a child is being abused or is likely to be abused, you're required by law to report it. That's it. And we don't, I don't think the prosecution for these are very common because I think most people just do the right thing and report child abuse. But especially, they're usually in settings where the abuse is obvious and their unwillingness to report is blatant.
Right. And the only thing that this bill is doing is changing the statute of limitations to allow more time between the discovery of the cover-up or the failure to report and an opportunity to prosecute, because sometimes it takes a while for the information to become known that's happened, and there are times when it's outside that window.
Because a lot of times you're dealing with children, you're dealing with outcry witnesses who may not outcry for years.
Right.
So you're trying to strike a balance. One, as we said, sometimes these things don't get reported or discovered till 2 or 3 years later, sometimes 20 years later, and so we're going from we're upping the limitation 1 year per classification here. You don't want to extend it too long, because after too long it becomes unfair to prosecute some of this because memories, witnesses are gone, things like that. But it seems like that this might be a reasonable.
Right, and so
Memories
it is 4 years for that state jail felony, 3 years for a misdemeanor.
And the defendant in these cases may not put up a defense, but if they do have a witness that could help them in their defense, you want that witness to be available and have a fresh memory. So there's a balancing there to keep it open long enough, but not too long, I would think. So, any other question, members? Okay, thank you, Mr. Money.
If there's any
let me ask if anybody wants to close. Wants to testify. We have. Is there anyone here who testify on, for, or against Senate Bill 127? If not, the chair recognizes Mr. Money to close.
Thank you for your patience, and appreciate it, and pray that you would, or ask that you would review this favorably and report it to, and pray about it too, to calendar so we can get this thing passed. Thank you.
Okay. If there's no objection, the chair will we'll leave Senate Bill 127 pending for now. Members, that concludes our bills. Now, let me add, would you prefer to do the photo now while we've got everybody together, or would you prefer to?
Oh, yeah. 10 minutes? It's just, we go
Yeah.
straight upstairs?
Yeah, it's Lady, it's
On
the
the
Lady
ground
Bird
level?
Garden.
Yeah.
Yeah.
Where?
Oh,
I know her staff's aware, I've been texting them, so she knows there's a photo.
Photoshop her in.
I'm sorry, where do we go?
We'll-
It's just upstairs in the extension. It's on the, north side. Isn't that where the Lady Bird Garden?
It's outside.
Yeah, that's where we pull into the drive.
Oh, in the little driveway?
Yeah, that's what we've always done.
Can we get ready?
Yes.
Okay. All right, so,
And we may have to wait like.
okay, so does that work for everyone? We'll do it quick.
Somebody text Rheta and get it over here.
Okay,
Where all the plants are.
Just make sure we adjourn before.
okay,
Circle.
okay. So
Can you all
if
tell
there's,
Rheta?
if there's no further business, the committee stands adjourned.
It's a long, long.